Welcome to the Pennsylvania Case Law Update While You Drive podcast. You give us less than 20 minutes per week, we will make sure you never miss changes in the law. This week's episode is brought to you by the McShane Firm. For nearly 20 years, the attorneys of the McShane Firm have been trusted by our neighbors and our friends to represent them in DUI and criminal law cases.
Thank you for joining us for episode 39 of the Pennsylvania Case Law Update While You Drive podcast. I'm your host, Katie McShane, and today we are covering cases decided between March 17th, 2021 and March 23rd, 2021. Today we have 4 criminal cases to discuss, and the links to all of the precedential cases this week can be found in the case notes. In the case of Commonwealth v. Wenzel, the defendant had an active arrest warrant. When the officers served the warrant and attempted to arrest the defendant, he resisted arrest and the police were forced to use substantial force to overcome the resistance. The defendant was convicted at trial and raises several issues on appeal. In his first issue, he claims the court erred in precluding the testimony of Joel Burkett, a doctor of chiropractic medicine. In order to be deemed an expert witness, the witness must possess more than expertise than is within the ordinary range of training, knowledge, intelligence, or experience. The determination of whether a witness is qualified to be an expert is left to the trial court's discretion and will only be overturned on an abuse of that discretion. In this case, it was determined that Dr. Burkett lied about his credentials. The trial court found that because of his lack of credentials and the fact that he lied about his credentials, he could not be qualified as an expert. Further, because any testimony would require specialized knowledge, he could also not testify as a lay witness. The Superior Court found no abuse of discretion. In his second issue, the defendant claims that the prosecution failed to disclose information related to an internal affairs investigation and that failure constituted a Brady violation. In order to establish a Brady violation, the defendant must prove that the evidence was suppressed by the state either willfully or inadvertently, the evidence was favorable to the defendant either because it is exculpatory or could be used for impeachment, and that the evidence was material and that its omission resulted in prejudice to the defendant. The court found here that because the Commonwealth did not even know about the investigation until after the trial, there was no evidence that it was willfully or inadvertently suppressed. As such, no Brady violation can be established. In addition, even if it was willfully or inadvertently suppressed, any error was harmless. In the next issue, the defendant claims the court erred in refusing to instruct the jury on self-defense and precluding the defense counsel from arguing self-defense in closing. In order to get a self-defense jury instruction, a valid claim of self-defense must be made out as a matter of law, and this determination must be made by the trial court. Here, it is undisputed that the defendant was aware the arresting officers were peace officers effectuating an arrest. Even if he believed that the arrest was unlawful, it did not justify the defendant's use of force. Thus, there was no basis upon which to instruct the jury on self-defense. The final issue raised is that the court erred by failing to compel the attendance of an officer subpoenaed by the defense. The defendant maintains that he served the witness a subpoena by certified mail or return receipt requested, but the subpoena was returned as unclaimed. Because defense could not show any proof of service, no relief is due. As the defendant is not entitled to relief on any claim, the judgment of the trial court is affirmed. The defendant in Commonwealth v. Murray was convicted of first-degree murder and several attendant charges following a robbery whereby he shot and killed the victim. On appeal, the defendant raises several issues. First, whether the trial court erred when it determined that the Commonwealth did not improperly use its peremptory strikes in a discriminatory manner in violation of Batson. During the trial, each side was allowed 8 peremptory challenges. The prosecution used 7 of their 8 challenges on African American or Hispanic jurors. Defense counsel objected and requested a race-neutral reason for striking the jurors. The defense challenged these strikes under Batson. A Batson claim presents mixed questions of law and fact. The standard of review is whether the legal conclusions are correct and whether the factual findings are clearly erroneous. In Batson, the United States Supreme Court held that a prosecutor's challenge to a potential juror solely on the basis of race violates the Equal Protection Clause of the United States Constitution. When making a Batson challenge, the defendant must first make a prima facie showing that the witness was stricken due to their race. Upon that showing, the prosecutor must put forth their race-neutral reason for striking the juror. In Pennsylvania, the defendant must also make a record specifically identifying the race and gender of all potential jurors in the pool, the race and gender of all jurors remaining after for-cause challenges, the race and gender of those removed by the Commonwealth, and the race and gender of the jurors who served and those who were acceptable to the Commonwealth but stricken by the defense. Here, the court found that the defendant failed to show a record of establishing purposeful discrimination. The defense did no more than point out the race of the stricken jurors and failed to establish the requirements on the record. Secondly, though it was likely not necessary for the prosecution to establish their race-neutral reason for striking the juror, as the defense failed to establish the required prima facie record, the court found that the prosecution had proper race-neutral reasons for striking the jurors. Therefore, the defendant is not entitled to relief. In his second claim, the defendant argues that the trial court abused its discretion by precluding testimony that a detective involved in the case was later convicted with tampering or fabricating evidence in an unrelated homicide case. In criminal cases where a defendant attempts to impeach a police witness with evidence of prior misconduct, the courts have balanced the scales between probative and prejudicial evidence. The case law permits a police witness to be cross-examined about misconduct as long as the wrongdoing is in some way related to the defendant's underlying criminal charges and establishes a motive to fabricate. However, if the police behavior is unrelated to the present matter and irrelevant, the trial court is permitted to restrict questioning of the incident. The Superior Court found that the trial court did not err in precluding the testimony. The court found that the evidence had very limited, if any, probative value and that its potential for prejudice outweighed that probative value. In his third issue, the defendant claims that the court erred by permitting a detective to testify about a hearsay statement by the defendant's girlfriend. The hearsay statement was offered was that the defendant's girlfriend told the officer that the defendant told her that he was in a fight. While the court concedes that this statement is in fact hearsay, the admission of the statement was harmless error. An error may be considered harmless where the error did not prejudice the defendant or the prejudice was de minimis. The erroneously admitted evidence was merely cumulative of other untainted evidence which was substantially similar to the erroneously admitted evidence, or the properly admitted and uncontradicted evidence of guilt was so overwhelming and the prejudicial effect of the error was so insignificant by comparison that the error could not have contributed to the verdict. In this case, the court found that the proof of the defendant's guilt was overwhelming and therefore the admission of the hearsay was insignificant and the error is harmless. In his final argument, the defendant claims that the court erred by refusing to include an option on the verdict sheet for the jury to convict the defendant of conspiracy to commit third-degree murder. The defendant cited no authority that permits the addition of a new charge to a verdict slip without a jury having been charged on that separate crime. Adding a new charge to the verdict without instructing the jury would likely have confused the jury in an already highly complex case. The court finds that the defendant is not entitled to any relief and the judgment of the trial court is affirmed. In the case of Commonwealth v. Rosario, the defendant appeals after being convicted of attempted murder and additional crimes at trial. In his first issue, the defendant claims that the trial court erred by failing to suppress a handgun that was found in his residence on the basis that Tyree King, the person who was house-sitting, was underage and did not have apparent authority to consent to search. In finding that King did have the authority, the trial court states that police must make a determination on whether the facts available to them at the moment would lead a reasonable person of reasonable caution to believe that the consenting party had authority over the premises. The trial court further stated that age by itself does not invalidate consent for search. The Superior Court agrees that King had apparent authority and that the police acted reasonably in their belief. This issue does not merit relief. In his second claim, the defendant argues that the trial court lacked sufficient evidence to convict him of conspiracy. With respect to conspiracy, the trier of fact must find that the defendant intended to commit or aid in the commission of a criminal act, the defendant entered into an agreement with another to engage in the crime, and the defendant and one or more other co-conspirator committed an overt act in furtherance of the agreed-upon crime. The defendant alleges that there is no evidence of agreement and that his actions were spontaneous, but the record does not support that conclusion. The Superior Court finds that there was sufficient evidence to sustain a conviction for criminal conspiracy. In his third issue, the defendant challenges the discretionary aspects of his sentence. Challenges to discretionary aspects of sentence are not automatic, and the defendant must satisfy a four-pronged test. The defendant must show that he preserved the issue by raising it at the time of sentencing or in a post-sentence motion, filed a timely notice of appeal, set forth a concise statement of reasons relied upon for the allowance of appeal, and raises a substantial question for review. The defendant satisfied the first three prongs. In determining whether the appeal raises a substantial question, the court must find that the defendant sets forth a plausible argument that the sentence violates a provision of the sentencing code or is contrary to the fundamental norms of the sentencing process. The Superior Court finds no merit to the defendant's contention that the trial court imposed a manifestly excessive sentence disproportionate to crimes of conviction. Due to the severe and brutal nature of the case, the court finds that the aggregate sentence is not grossly disparate to the defendant's conduct. The defendant also claims that the sentence violates the Eighth Amendment protections against cruel and unusual punishment. The three-part test for Eighth Amendment proportionality review includes the gravity of the offense and the harshness of the penalty, the sentences imposed on other criminals in the same jurisdiction, and the sentence imposed for the same crime in other jurisdictions. If the first prong is satisfied, the court need not establish the second or third. Here, the court properly found that the sentence was not disproportionate to the crime. In his next claim, the defendant alleges an illegal sentence as to the crime of conspiracy. Based on the facts and that the victim was not killed, the defendant could not be sentenced on both inchoate crimes of attempt and conspiracy. Therefore, the sentence for the conspiracy charge is vacated. He also raised a question of legality of sentence on the 2 kidnapping counts. The court found that the record supported only a single count of kidnapping and was not persuaded by the Commonwealth's argument. The court thereby vacated the sentences regarding the 2 kidnapping counts. The convictions are affirmed, but the case is remanded for sentencing consistent with this opinion. The final case for the week is Commonwealth v. Lopez. In this case, the defendant was sentenced to incarceration and mandatory court costs after being revoked from probation several times. He requested an ability to pay hearing prior to sentencing, which was denied by the court. The defendant appealed on the basis that an ability to pay hearing is required. However, the statute that the defendant refers to, when read in context with its surrounding sections, only requires a court to determine a defendant's ability to pay before incarceration for delinquency, not before the imposition of all financial obligations at sentencing. The court finds that the trial court properly found it was not required to have an ability to pay hearing in this case, and that while the rule permits a defendant to demonstrate financial inability either after a default hearing or when costs are initially ordered, the rule only requires such a hearing prior to any order directing incarceration for failure to pay ordered costs. Therefore, there is no relief due to the defendant. That's all I have for this week. Thank you once again for joining us, and I hope everyone has a great week.
Thank you for listening to the Pennsylvania Case Law Update While You Drive podcast. Be sure to subscribe to this podcast and our YouTube channel to make sure that you are always in the know when it comes to important changes in Pennsylvania case law. We want to thank this week's sponsor, the McShane Firm. The McShane Firm is a central Pennsylvania fixture when it comes to DUI and criminal defense. The attorneys and staff at the McShane Firm believe in good old-fashioned central Pennsylvania values like hard work and straight talking. Give them a call if you or a loved one ever needs help.